Before we begin, a quick and important disclaimer. The information provided in this video is for educational and entertainment purposes only and does not constitute legal, financial, or tax advice. Divorce law and retirement account regulations vary significantly by state, jurisdiction, and specific plan provider. We are not your attorneys or financial advisors. You should conduct your own due diligence and consult with qualified professionals regarding your specific situation before making any decisions. This content is intended to provide a high-level overview of historical trends and case studies in the field of U.S. social sciences and financial law. Imagine working for 35 years, hitting every contribution milestone, and watching your 401k compound into a seven-figure nest egg. You have planned the cruises, the mountain cabin, and the quiet mornings of a hard-earned retirement. Then, in a single afternoon, a judge in a mahogany-paneled room signs a document that instantly transfers half of that work, 18 years of your labor, to someone who is no longer in your life. This is the reality of the 401k divorce in the United States, a phenomenon that social scientists are calling the most significant and complex wealth transfer in modern American history. Most people believe their retirement account is a personal, untouchable fortress because their name is the only one on the statement. In reality, under the eyes of U.S. social and legal structures, that account is not a personal savings jar. It is a marital asset, a fruit of a legal partnership that is subject to total or partial liquidation upon the dissolution of that partnership. Today, we are opening a deep dive masterclass into the social science of 401k division. We are going to explore why the divorce rate for those over 50 has tripled since 1990, creating a silver tsunami of asset redistribution that most people are completely unprepared for. By the end of this session, you will understand the ERISA labyrinth, the true power of a qualified domestic relations order, and how the difference between community property and equitable distribution could mean the difference between a comfortable retirement and a total financial restart at age 60. To understand why a 401k is such a volatile element in a divorce, we first have to look at the historical and sociological shift in how Americans save for the future. 50 years ago, the primary vehicle for retirement was the pension, a defined benefit plan where the employer took on the risk and the payout was a steady stream of income. Social scientists note that dividing a pension was relatively straightforward because it was a future promise of a monthly check. However, following the Employee Retirement Income Security Act of 1974, or ERISA, the landscape shifted toward the 401k, a defined contribution plan. This placed the ownership, the risk, and the visible pile of cash directly in the hands of the individual. This shift fundamentally changed the social contract of marriage. Suddenly, a spouse wasn't just waiting for a shared pension. They were looking at a liquid account balance that grew every month. In the context of a divorce, that 401k becomes the largest liquid asset next to the family home, and often it is far more valuable because you cannot easily liquidate a house to pay for groceries in retirement. The social sciences tell us that divorce is not just an emotional event. It is an economic divorce of a business partnership. In the United States, there are two primary legal frameworks that dictate how your 401k is viewed during this split: community property and equitable distribution. If you live in one of the 9 community property states, such as California, Texas, or Arizona, the law generally views everything acquired during the marriage as owned 50-50 by both partners, regardless of whose paycheck funded the account. If you married with $0 and retired with $2 million, $1 million belongs to each spouse. Period. However, the other 41 states follow equitable distribution. This is where the social science gets messy. Equitable does not mean equal. It means fair. A judge might look at a 20-year marriage and decide that because one spouse stayed home to raise children, allowing the other to maximize their 401k contributions and career growth, the non-working spouse is entitled to 60% of the account to balance out their lack of Social Security credits and future earning potential. Plus 2. Let's look at a historical trend that is currently reshaping American demographics: the Gray Divorce. According to data from the National Center for Family and Marriage Research, while divorce rates for younger couples have actually stabilized or even declined, the rate for adults over the age of 50 has skyrocketed. This group, often called the baby boomers, holds the vast majority of the nation's 401k wealth. Social scientists suggest several reasons for this, including longer life expectancies and the decreased social stigma of later life separation. However, the financial impact is devastating. A case study from 2024 showed that women over 50 who go through a divorce experience a 45% decline in their standard of living, whereas men experience a 21% decline. The primary culprit for this gap is the mismanagement of retirement asset division. Plus 2. The most critical tool in this process is the Qualified Domestic Relations Order, or QDRO. This is a specialized legal document that most people have never heard of until they are in the middle of a crisis. You cannot simply walk into your HR department with a divorce decree and tell them to give half of your 401k to your ex-spouse. Doing so would be considered an early withdrawal by the IRS, triggering immediate income taxes and a 10% penalty. The QDRO is a federal mechanism under ERISA that allows for the tax-free transfer of retirement funds from one spouse to an alternate payee. Plus 1. Think of the QDRO as a legal bridge. It must be drafted by an expert, approved by the court, and most importantly, approved by the 401k plan administrator. If the plan administrator finds a single typo or a violation of the specific plan's rules, they will reject it, leaving the assets in limbo while legal fees continue to mount. Consider the case study of the $80,000 typo. In a historical case analyzed by social scientists focusing on financial litigation, a couple agreed to split an $800,000 401k account. They drafted a simple agreement stating the ex-wife would receive $400,000. However, they failed to account for gains and losses during the 6 months it took the court to process the paperwork. During that window, the market surged. The account grew to $960,000. Because the document specified a flat dollar amount of $400,000 rather than a percentage, the account holder kept the entire $160,000 gain, even though half of that gain was technically generated by the portion of the money that belonged to the ex-spouse. The resulting litigation to correct this oversight cost both parties tens of thousands of dollars and years of stress. Furthermore, social science researchers have identified a phenomenon known as the 401k offset trap. This occurs when one spouse wants to keep the family home and agrees to let the other spouse keep the entire 401k of equal value. On paper, it looks like a fair trade, a $500,000 house for a $500,000 401k. But this is a mathematical illusion. The house is purchased with post-tax dollars, and depending on capital gains exemptions, much of its value can be accessed tax-free. The 401k, however, is a ticking tax time bomb. When that spouse goes to withdraw the $500,000 in retirement, they may have to pay 20 to 30% in federal and state income taxes. In reality, the spouse who kept the 401k received only $350,000 in spendable wealth, while the spouse with the house received the full $500,000. Understanding these potential outcomes is why social science perspectives on finance are becoming mandatory for anyone navigating a mid to late life divorce in the U.S. We also have to discuss the concept of tracing and separate property. If you started your 401k 5 years before you got married, that initial balance and its growth might be considered your separate property. However, the burden of proof is on you. This requires what social scientists call financial archaeology. You must be able to produce statements from decades ago to prove exactly what was in the account on the day you said, "I do." If you cannot prove it, the court may transmute the entire account into marital property, effectively giving your spouse a windfall of your premarital labor. This deep dive is about more than just numbers. It is about the intersection of law, sociology, and human behavior. We are seeing a shift where the 401k is no longer just a retirement tool. It is a bargaining chip, a source of leverage, and unfortunately, a source of immense poverty for those who do not understand the rules of the game. As we move through this 10-part series, we will break down the specific steps for securing a QDRO, the hidden tax benefits of Section 72(d)(2)(c), which allows for penalty-free withdrawals during a divorce, and the sociological reasons why men and women approach these negotiations so differently. This is your masterclass in the social science of the 401k divorce. To understand the true weight of a 401k in a divorce, we must first confront the invisible wall of federal law known as ERISA preemption. While your local family court judge has the power to grant a divorce and divide your physical assets, they technically have no direct authority over your 401k plan administrator. This is because the Employee Retirement Income Security Act of 1974 is a federal statute that supersedes state law. In the social sciences of American litigation, this creates a unique friction point. You might have a signed court order from a state judge saying your spouse gets exactly half of your retirement, but if that order does not meet the hyper-specific federal criteria of a qualified domestic relations order, the plan administrator will simply ignore it. This leads to a sociological phenomenon where thousands of Americans believe their financial transition is settled, only to find themselves locked in a multi-year administrative battle with the corporate benefits department. Let us look at a case study involving a couple we will call James and Elena, navigating their separation in the current landscape of 2026. James is a senior systems engineer who has contributed to his 401k for 20 years. Elena has worked part-time while managing the logistics of their household and their 2 children. In 2026, the 401k is valued at $1.4 million. In the eyes of many, this is a simple math problem of dividing by 2. However, social science research into financial equity reveals that the timing of these contributions changes everything. James started the account 5 years before the marriage. During those 5 years, he contributed $100,000. By the time he married Elena, that $100,000 had grown to $150,000 through market appreciation. To the court, that $150,000 is separate property. But here is where the complexity deepens. The growth on that separate $150,000 over the next 15 years of marriage must be categorized. Is the growth considered active or passive? If the growth occurred because James actively managed the trades and shifted allocations during the marriage, some jurisdictions may argue that his labor as a fund manager was a marital effort, potentially turning some of that growth into a marital asset. If the growth was purely a result of market forces, it might remain separate. Tracing these funds requires a level of financial archaeology that involves analyzing every quarterly statement from 2006 to 2026. If James cannot produce those statements, perhaps because the old record keeper was acquired by another firm, the court may default to the assumption that the entire $1.4 million is a marital asset. This historical trend of record-keeping gaps often results in the unintended redistribution of premarital wealth. Now we must examine a specific mechanism that provides a rare financial lifeline during a divorce, often referred to by social scientists as the 72T bridge. Under Internal Revenue Code Section 72T, 2C, there is a specific exception to the 10% early withdrawal penalty. Typically, if you are under the age of 59 and a half and you take a distribution from your 401k, the IRS takes 10% off the top as a penalty, in addition to regular income taxes. However, if the distribution is made to an alternate payee, the ex-spouse, pursuant to a valid QDRO, that 10% penalty is waived. Imagine if Elena needs $100,000 immediately to secure a down payment on a new home in the high interest rate environment of 2026. If she were to take that money from her own retirement account, she would lose $10,000 instantly to the penalty. But by receiving it directly from James's 401k via the QDRO, she avoids the penalty entirely. She still owes income tax, but the waiver of the penalty represents a significant preservation of capital. This is a potential outcome that savvy negotiators use to provide liquidity to the spouse who may be cash poor but asset rich. However, the sociological impact of this cash out can be devastating long-term. Case studies show that many alternate payees, overwhelmed by the immediate costs of establishing a new household, choose to take their entire QDRO portion as a cash distribution rather than rolling it over into an individual retirement account. By doing so, they not only pay a massive tax bill in a single year, potentially pushing them into the highest tax bracket, but they also forfeit the compounding growth that would have occurred over the next decade. In the context of the U.S. social sciences, this is known as the retirement gap. We see a historical trend where women, who are more likely to be the alternate payee in these scenarios, end up with significantly lower retirement security in their 70s because they use their 401k split to solve short-term housing crises in their 50s. We must also discuss the technical distinction between the two main types of QDROs, the separate interest approach and the shared interest approach. This is where many couples make a mistake that haunts them for decades. In a separate interest QDRO, the account is literally split into 2 independent accounts. Elena gets her own account within the plan, and she can decide when to start her benefits and who her beneficiaries will be. This is generally preferred in the social sciences of divorce because it provides a clean break. James can retire when he wants, and Elena can retire when she wants. Contrast this with the shared interest approach, which is often used when the employee is already receiving payments or is very close to retirement. In this model, Elena only receives a portion of each check that James receives. The sociological risk here is that her financial security is tethered to his life. If the QDRO is not drafted with specific survivor benefit protections, and James passes away, Elena's income stream could vanish instantly. This creates a power imbalance that social scientists point to as a form of post-divorce financial vulnerability. The year 2026 has brought new challenges to this division, specifically regarding market volatility and valuation dates. Imagine if James and Elena filed for divorce in January, when the account was at $1.4 million. By the time they reach a final agreement in June, the market has dipped, and the account is now worth $1.2 million. If their agreement was written to give Elena a flat amount of $700,000 based on the January value, James is now forced to give up nearly 60% of the actual remaining balance. Conversely, if the market had spiked to $1.6 million, Elena would be receiving much less than half of the current value. Social science data suggests that the choice of a valuation date is one of the most litigated points in modern divorce. Experts recommend using a percentage-based split including gains and losses up to the date of distribution to ensure the risk and reward of the market are shared equally. Step by step, the process involves more than just a lawyer. You have the participant, the alternate payee, the two attorneys, the actuary who might be needed to value the separate property, and the plan administrator. Each of these actors has a different motivation. The plan administrator's only goal is to minimize liability for the company. They will reject a QDRO for the smallest deviation from their internal manual. This brings us to a critical realization. The 401k is not just a bucket of money, it is a legal contract with its own set of bylaws. Why do we see such a divergence in how men and women approach these negotiations? Behavioral economics tells us about the endowment effect, the tendency to overvalue something simply because you own it. For the spouse whose name has been on the 401k for 20 years, the account feels like a part of their identity. For the other spouse, it often feels like a theoretical number on a screen. This leads to a negotiation style where one party may fight harder for the 401k than for the family home, even when the math suggests the house is the better asset. We are seeing a shift in 2026 where more couples are opting for asset swaps to avoid the complexity of the QDRO entirely. But as we discussed earlier, the tax-adjusted value of these swaps is rarely calculated correctly. If you believe that simply signing the papers and walking away is the end of the story, you are ignoring the most dangerous phase of the process, the execution gap. There is a period between the divorce decree and the actual transfer of funds where the account holder still has total control. What happens if the participant takes a massive loan against the 401k right before the QDRO is processed? What happens if they change the investment allocation to high-risk options that crash the value before the split occurs? These are the hidden risks that can turn a fair settlement into a financial disaster. As we move forward, we have to look at the darker side of retirement division, the hidden loans and the impact of the 401k loan default. If there is an outstanding loan on the 401k at the time of the divorce, who is responsible for paying it back? If it isn't paid, it becomes a taxable distribution. In our next part, we are going to dive into the nightmare scenario of the 401k loan trap and the specific language you must include in a settlement to prevent your ex-spouse's debt from becoming your tax bill. We will also explore how 2026 inflation rates are changing the way actuaries calculate the present value of future benefits. The math is changing, and if you are using 2020 logic in a 2026 world, you are already behind. One of the most dangerous and frequently overlooked hurdles in the division of retirement assets is the 401k loan trap. To understand the gravity of this, we must look at a case study from the early months of 2026 involving a couple named Marcus and Sarah. Marcus, a senior project manager, had been contributing to his 401k for 18 years. In late 2025, as the marriage began to fray, Marcus took out a $50,000 loan from his 401k. On the surface, he used the funds to consolidate high-interest credit card debt that the couple had accrued during a period of heavy inflation. However, in the social science of divorce litigation, this move created a financial landmine that exploded during their 2026 discovery process. In the United States, a 401k loan is not like a bank loan. You are essentially borrowing from your future self. The plan administrator moves the $50,000 out of your investment funds and into a separate loan account. Your total account balance might still say $450,000, but $50,000 of that is now an IOU from you to the plan. This creates an immediate problem for the court. Is the value of the marital asset $450,000 or is it $400,000? Historical trends in family law suggest that if the loan was used for marital purposes, such as the credit card debt in Marcus and Sarah's case, the court might treat the $50,000 debt as a marital liability. This means Sarah's 50% share would be calculated based on the net value of $400,000, giving her $200,000. But imagine if Marcus had used that $50,000 for a non-marital purpose, such as a secret down payment on an apartment for a new partner, or a high-stakes cryptocurrency investment that went to zero. In the social sciences, this is categorized as the dissipation of marital assets or financial infidelity. If Sarah's legal team can prove this dissipation, the court may engage in a process called adding back. The judge would treat the 401k as if the $50,000 were still there, valuing the account at $450,000. Sarah would be awarded $225,000, leaving Marcus with only $175,000 once the $50,000 debt is subtracted from his portion. This step-by-step reconstruction of the 401k history is a mandatory part of any deep-dive financial audit in 2026. Beyond the valuation, there is the nightmare of the 401k loan default. Under the Internal Revenue Code Section 72P, a 401k loan must be repaid within 5 years, usually through payroll deductions. When Marcus and Sarah finalize their divorce, Marcus might leave his job or simply stop making payments. If he defaults, the IRS treats the remaining balance of the loan as a deemed distribution. This triggers immediate income tax and, if Marcus is under 59.5, a 10% early withdrawal penalty. If the divorce settlement did not specifically address who is responsible for the taxes on a defaulted loan, Sarah could find herself fighting the IRS for a tax bill generated by Marcus's default. Potential outcomes in these scenarios often involve the non-participant spouse demanding a hold harmless clause in the settlement, which stipulates that the person who took the loan is solely responsible for any tax consequences resulting from a default. This leads us into the shifting landscape of 2026 actuarial science. Actuaries are the professionals who calculate the present value of future money, and in 2026, their formulas are undergoing a radical shift due to the persistent inflation and higher interest rates of the mid-2020s. In 2020, an actuary might have used a 2% discount rate to determine what a 401k would be worth in 20 years. In 2026, with higher baseline interest rates, that discount rate might be 5 or 6%. This changes the math of the offset. If Marcus wants to keep his entire 401k and give Sarah the family home instead, the actuary must determine the tax-adjusted present value of that 401k. Because of 2026 inflation, the purchasing power of $1 20 years from now is significantly lower than it was projected to be in 2020. This means that a 401k balance today is technically worth less in terms of future lifestyle than it was 5 years ago. Social science researchers have noted that many spouses are getting shortchanged because they are using outdated 2020 logic to value their 2026 assets. They see a large number on a 401k statement and assume it is worth its face value, failing to account for the fact that the tax burden and the inflation-adjusted value will eat away at that nest egg. To truly understand the value of a 401k in a divorce, you must apply a tax-effective discount. If you are in a 25% tax bracket, every dollar in that 401k is only worth 75 cents in the real world. If you ignore this, you are effectively overpaying for your own retirement account during the asset split. Furthermore, we must address the sociological concept of the gatekeeper in the 401k system, the plan administrator. Every 401k plan is governed by a Summary Plan Description or SPD. This is the secret Bible of your retirement account. It contains the specific rules for how the plan handles a qualified domestic relations order. Some plans allow for an immediate lump sum distribution to the ex-spouse. Others require the ex-spouse to wait until the participant reaches a certain age. In 2026, we are seeing a trend where plan administrators are becoming increasingly rigid. If your divorce decree says you get 50% of the account as of the date of separation, but the plan administrator's manual says they only calculate valuations on the last day of the quarter, you have a $30,000 problem if the market moves during those 3 months. The step-by-step solution to this is to subpoena the summary plan description and the QDRO procedures before you even start negotiating. In our case study, Sarah's attorney requested these documents early. They discovered that Marcus's plan had a specific provision regarding 401k loans. The loan must be fully repaid or offset before any QDRO can be processed. This meant that the $50,000 loan was not just a debt, it was a physical barrier to Sarah getting her money. Without this knowledge, Sarah might have signed a deal that would have left her waiting years for Marcus to pay back a loan he had no intention of prioritizing. Social scientists specializing in behavioral finance have also identified the regret phase of the 401k divorce. This is where the participant, after seeing their account balance slashed in half, experiences a psychological shutdown. They may stop contributing to the plan altogether, feeling that the system is rigged against them. In 2026, data suggests that individuals who go through a 401k split are 30% less likely to reach their original retirement goals, not just because of the asset loss, but because of this psychological withdrawal from the saving process. Understanding that the 401k is a tool for the future, not just a record of the past, is vital for moving forward. But what if the unthinkable happens? What if the paperwork is signed, the judge has approved the divorce, but the QDRO hasn't been finalized by the plan administrator yet? During this limbo period, the participant still holds the legal title to the account. If they were to pass away tomorrow, who gets the money? Most people assume the divorce decree overrides everything. In the world of federal ERISA law, that assumption is a multi-million-dollar mistake. The beneficiary designation form on file with the employer often carries more weight than a state court judge's signature. In our next part, we are going to dive into the beneficiary designation trap, a scenario where an ex-spouse can legally inherit a 401k they were supposed to give up, leaving the new family or the intended heirs with absolutely nothing. We will also explore the little-known world of the 401k shadow accounts and how companies are using automated systems in 2026 to flag and freeze accounts the moment a divorce is mentioned. If you haven't secured your digital access, you might be locked out of your own data exactly when you need it most. The digital lockout is just the first layer of a much deeper, more consequential trap that social scientists call the beneficiary designation paradox. To understand this, we need to look at a landmark historical trend established by the Supreme Court in cases like Egelhoff versus Egelhoff and Kennedy versus Plan Administrator for the Savings and Investment Plan. These cases established a terrifying precedent for anyone going through a divorce in the United States. The paperwork you signed at the HR office 15 years ago often carries more weight than a signed divorce decree from a state judge. Imagine a character named David in the year 2026. David is a high-level marketing executive who finalized his divorce from his first wife, Sarah, in early 2024. In their divorce decree, Sarah explicitly waived all rights to David's 401k, which at the time was valued at $900,000. David eventually remarried a woman named Maria in 2025. In David's mind, the divorce decree was a shield. He believed that because a judge had signed a paper saying Sarah had no claim to the money, Maria was naturally his new heir. However, David never logged into his 2026 benefits portal to physically change the beneficiary designation form. When David unexpectedly passes away in late 2026, the plan administrator looks at one thing and one thing only: the beneficiary form on file. Under federal ERISA law, the plan administrator is legally required to pay the person named on that form, regardless of what the state divorce decree says. In this case study, Sarah receives the entire $900,000. Maria, the current spouse, takes the case to court, but historical trends show that federal law preempts state law. Because the 401k is a federal instrument, the plan administrator cannot be held liable for following the plan documents. This results in what social scientists describe as an accidental wealth transfer, where billions of dollars in the U.S. are paid out to ex-spouses every decade simply because of an administrative oversight during the chaos of a life transition. This brings us to the sociological concept of the inertia bias. In the social sciences, researchers have found that during high-stress events like a divorce, the human brain suffers from extreme decision fatigue. By the time a couple has negotiated child custody, the sale of the home, and the division of physical property, they are cognitively exhausted. The 401k beneficiary form is often viewed as a minor clerical detail, rather than a primary legal instrument. Data from 2026 shows that nearly 35% of divorced individuals in the U.S. still have an ex-spouse listed as a primary or contingent beneficiary on at least one retirement account. To navigate this, you must understand the step-by-step process of a beneficiary audit in the current 2026 landscape. First, you must distinguish between your 401k and your IRA. While 401k plans are governed by ERISA and federal law, IRAs are often governed by state contract law. This creates a confusing patchwork where an ex-spouse might be automatically removed from an IRA by state statute upon divorce, but remains the legal beneficiary of a 401k. Step 2 involves the 2026 digital portal, Many major U.S. employers have now moved to automated benefit systems that use biometric or multi-factor authentication. If you are locked out of these systems during the divorce, you cannot verify your beneficiaries. Furthermore, in 2026, many fintech companies have integrated PlanSentry AI or similar automated systems that monitor public court dockets. The moment a divorce petition is filed in a U.S. county, these systems may trigger an administrative hold on the account. This is a double-edged sword. On one hand, it prevents a vengeful spouse from draining the account or changing the beneficiary to a random third party before the court can act. On the other hand, it can freeze your ability to rebalance your portfolio. If the market takes a downturn in 2026 while your account is under a divorce-related freeze, you may be forced to watch your retirement savings dwindle without the ability to move into safer assets like money market funds or bonds. The social science of 401k management also reveals the hidden risk of the shadow account. When a qualified domestic relations order is finally approved by a plan administrator, they don't just send a check to the ex-spouse. Instead, they often perform a segregation of assets. They create a new, separate account for the ex-spouse, the alternate payee within the same plan. For a period of time, these two accounts exist in a tandem relationship. However, if the plan administrator makes a calculation error during this segregation, it can lead to a fiduciary breach. In 2026, with the increasing complexity of target date funds and automated rebalancing, the math required to split these accounts is more prone to error than ever before. Imagine if the account was invested in a custom employer stock fund. If the stock price fluctuates wildly between the date of the court order and the date the shadow account is actually funded, who bears that risk? Social science researchers focusing on financial litigation have noted a rise in 2026 of what they call the execution gap. This is the timeline between when a judge says you have the money and when the computer system actually reflects that reality. During this gap, the account is often in a state of digital limbo. There is also the sociological impact of the 401k loan offset during this phase. If David, in our earlier example, had an outstanding loan of $40,000 when the account was split, the plan administrator might treat that loan as a distribution to him. This means his side of the account is reduced by $40,000, but he also receives a 1099 or tax form for that amount. If Maria is the one receiving the other half of the account, she needs to ensure the QDRO language accounts for this loan. If it doesn't, she might find her half of the account is significantly smaller than she anticipated because the loan was subtracted from the total balance before the 50-50 split was calculated. To truly master the social science of the 401k divorce, we must also look at the role of the plan fiduciary. Under ERISA Section 404, the people running your 401k have a duty to act solely in the interest of the participants and beneficiaries. However, in the context of a divorce, their definition of a beneficiary is strictly limited to who is on the piece of paper. They are not required to be fair. They are required to be compliant with the plan documents. This creates a systemic rigidity that catches many American families off guard. As we look toward the future of retirement law, the intersection of technology and sociology is making these divisions faster, but also more prone to systemic errors. The 2026 environment requires a level of digital literacy that previous generations didn't need. You are no longer just fighting a legal battle in a courtroom. You are fighting a data battle in a corporate database. If the data is wrong, the law might not be able to save you. But there is an even more insidious threat lurking in the shadows of the 401k split, something social scientists call the tax phantom. It is a situation where you receive a portion of a retirement account, but you also unknowingly inherit a massive tax liability that belonged to your spouse. In our next part, we are going to break down the specific IRS codes that govern how these taxes are shifted, and how a single missing sentence in your QDRO can lead to you paying the government for your ex-spouse's past financial mistakes. We will also explore the psychological warfare of the 401k appraisal, and why people often fight harder for a retirement account than they do for their own house. The tax phantom is a sociological and financial phenomenon where the perceived value of a 401k account is fundamentally disconnected from its actual spendable utility. In the social sciences of American divorce, this often manifests as one spouse unknowingly volunteering to pay the government for the privilege of dividing their assets. To understand this, we must look at the specific 2026 tax landscape. By mid-2026, tax brackets and standard deductions have evolved, making the deferred tax liability inside a traditional 401k a massive, invisible lien held by the IRS. Imagine a case study involving Alex and Taylor. After 15 years of marriage, They are dividing their assets in 2026. Their primary holdings are a family home with $500,000 in equity and Alex's 401k, which is also valued at exactly $500,000. In a standard negotiation, Taylor might say, "I will take the house, and you keep your 401k. On the surface, this looks like a perfect 50-50 split. However, social science research into financial literacy during divorce reveals that this is almost always a catastrophic mistake for the spouse keeping the 401k. The house equity is post-tax. If Taylor sells the home, they may benefit from the Section 121 exclusion, allowing them to keep up to $250,000 of gain tax-free. In contrast, Alex's 401k is a pre-tax asset. Every single dollar in that account is a debt to the IRS that hasn't been paid yet. If Alex is in a 24% tax bracket in 2026, that $500,000 account is actually only worth $380,000 in real-world purchasing power. By agreeing to this trade, Alex has essentially handed Taylor $120,000 of extra wealth without realizing it. This is the tax phantom in action. It is a hidden redistribution of wealth that occurs because one party is valuing a gross number, while the other is receiving a net asset. Under Internal Revenue Code Section 402(1)(a), when a 401k is divided via a qualified domestic relations order, the alternate payee, the spouse receiving the funds, becomes the distributee for tax purposes. This is a critical legal lever. If the QDRO is drafted correctly, Taylor could receive $250,000 from the 401k and roll it into their own IRA, maintaining the tax-deferred status. But if they choose to cash it out to pay for post-divorce living expenses, they, not Alex, will be responsible for the income tax. Potential outcomes vary wildly depending on whether the legal team includes a tax adjustment clause in the settlement. In 2026, advanced negotiators are using what is known as a tax-affected valuation, where the 401k balance is artificially discounted by 20% before the split even begins to account for this future liability. This leads us directly into the psychological warfare of the 401k appraisal. Social scientists have long studied the endowment effect, which is the tendency for people to overvalue things simply because they feel a sense of ownership. In the context of a 401k, this effect is amplified. For someone like Alex, that 401k represents 15 years of late nights, missed vacations, and professional stress. It is not just an account, it is a chronological record of their labor. Taylor, on the other hand, may view the account through the lens of a scarcity mindset. In the economic uncertainty of 2026, a 401k represents a safety net that is portable, unlike a house which is tied to a specific geographic market and requires constant maintenance. Data from historical trends in 2025 and 2026 suggests that men are statistically more likely to fight for the 401k, even when the math suggests they should take the house. Why? Because the 401k is liquid security. It is a number on a phone screen that can be checked daily, providing a psychological hit of certainty in an uncertain divorce. A house, conversely, is a liability in the eyes of many 2026 divorcees. It requires repairs, property taxes, and insurance, all of which are increasing in cost. Social scientists call this the liability asset inversion, where traditional assets like real estate are being traded away for the perceived stability of a retirement account. Step by step, the appraisal process for a 401k in 2026 requires more than just looking at a statement. You must first segregate the account into its component parts. Is there a Roth component? If Alex has been making Roth 401k contributions, that money is post-tax and is far more valuable than the traditional pre-tax portion. If the divorce decree simply says 50% of the account, and the plan administrator assigns the entire Roth portion to Taylor while giving Alex the traditional portion, Alex has been financially gutted. Step 2 involves the analysis of net unrealized appreciation, or NUA. This applies if the 401k holds shares of the employer's stock. In 2026, many tech and manufacturing employees have significant portions of their 401k in company stock. NUA allows the participant to pull the stock out of the 401k and pay only capital gains tax on the growth, rather than ordinary income tax. This is a massive tax advantage. If the QDRO does not specifically address how the NUA rights are divided, the spouse who receives the transfer might lose this benefit entirely, as many plan administrators do not allow NUA to be preserved for the alternate payee unless specific, hyper-technical language is used. The warfare intensifies during the valuation date selection. Imagine the market volatility of 2026. A 401k invested in aggressive growth funds could swing 5% in a single week. If the parties agreed to a valuation date of June 1st, but the QDRO isn't processed until September 1st, and the market has crashed in the interim, who loses? If the order was for a specific dollar amount, say $200,000, the spouse keeping the account takes the entire loss. If the account dropped from $400,000 to $300,000, and the spouse has to pay out $200,000, they are left with only $100,000, a far cry from the 50-50 split they imagined. Case studies in 2026 show a rising trend of litigation over these gap periods, with courts increasingly moving toward percentage-based splits with gains and losses applied until the moment of distribution. But why do people fight harder for this than their own house? Beyond the endowment effect, there is the concept of the identity wealth link. In the US, your 401k is often the only tangible proof of a successful career. Losing half of it feels like the court is saying your career was only half as successful as you thought. This emotional bruising leads to irrational bargaining. We see participants willing to take on massive debts or give up valuable personal property just to see that 401k number remain as high as possible. They are effectively buying back their own labor at a premium, often ignored by their own legal counsel who may not understand the tax-adjusted math. In the 2026 landscape, we are also seeing the emergence of the 401k lien. This is where a spouse who is owed alimony or child support places a lien against the other's retirement account. Even if you don't divide the account today, it can be held hostage for future obligations. This creates a psychological weight where the participant feels they are working for their ex-spouse every time they see their 401k contribution leave their paycheck. As we peel back the layers of this masterclass, we move from the math of taxes and the psychology of ownership into the mechanical world of the transfer itself. Most people think a QDRO is the end of the line, but there is a hidden phase that can take months or even years to resolve. What happens when the company goes bankrupt during the transfer? What happens if the plan is merged with another company's plan while your QDRO is sitting in an inbox? In our next part, we are going to explore the corporate merger nightmare and the ERISA black hole. We will look at how the massive wave of corporate acquisitions in 2026 is leaving thousands of divorcees with frozen accounts and no clear path to their money. We will also dive into the specifics of the 401k catch-up provision and how a divorce in your 50s can actually be used to legally supercharge your contributions beyond the normal IRS limits. The system is rigged with traps, but if you know where the hidden triggers are, you can turn a financial disaster into a strategic recovery. The corporate merger nightmare is not a hypothetical scenario in 2026. It is a statistical probability that every divorce litigant must account for when dividing retirement assets. We are currently witnessing an era of massive corporate consolidation across the U.S. healthcare and technology sectors. In the social sciences of labor economics, this creates what is known as structural volatility. For a person going through a 401k split, this volatility translates into a phenomenon called administrative purgatory. Imagine a character named Linda in the year 2026. Linda is 56 years old and is finalizing a divorce after 28 years of marriage. Her husband, an executive at a mid-sized fintech firm, has a 401k valued at $1.8 million. In April 2026, just as Linda's legal team submits their draft-qualified domestic relations order to the plan administrator, the fintech firm is acquired by a global banking conglomerate. This is where the ERISA black hole opens up. When a merger occurs, the acquiring company often moves all employee data to a new record keeper. This transition involves a blackout period. According to historical trends in Department of Labor oversight, a blackout period typically lasts between 30 and 60 days. During this window, no participant can move money, change investment allocations, or process a withdrawal. For Linda, the timing is catastrophic. The $1.8 million account is frozen. While the account is in limbo, the global banking conglomerate decides to overhaul the retirement plan options, moving funds from high-growth aggressive portfolios into more conservative stable value funds to align with their corporate risk profile. By the time the blackout ends and the new plan administrator looks at Linda's QDRO, the market has shifted, the fund names have changed, and the original plan listed in her court order technically no longer exists. The social science of bureaucracy tells us that systems prioritize their own internal logic over individual needs. The new plan administrator may reject Linda's QDRO because it references a defunct plan. Linda is then forced back into court to amend the order, incurring thousands of dollars in additional legal fees and losing months of potential market gains. To mitigate such potential outcomes, advanced legal practitioners in 2026 are using successor and interest clauses in their settlements. This specific language ensures that the court order remains binding on any future company that acquires the current employer. Without this clause, you are essentially gambling that your spouse's company remains a stagnant entity until the check clears. Beyond the chaos of mergers, we must address the strategic recovery phase of a 401k divorce, particularly the 2026 implications of the Secure 2.0 Act. For those in their 50s and 60s like Linda, a divorce can be the catalyst for a total financial restructuring. In 2026, the IRS has implemented significantly higher catch-up contribution limits for individuals aged 60 through 63. This is a critical pivot point in the masterclass. If you are the spouse receiving a distribution via QDRO, you have a unique opportunity to legally supercharge your own retirement. Consider this step-by-step scenario. Linda receives $900,000 from her ex-husband's 401k. Instead of taking it as a cash distribution and paying the tax phantom, she rolls it into her own employer-sponsored 401k or a rollover IRA. Because she is over the age of 55 and has experienced a loss of marital household income, she can now utilize her own earnings to maximize the 2026 catch-up provisions. For the 2026 tax year, the standard 401k contribution limit is $23,500. But for those in the 60 to 63 bracket, the catch-up limit has been boosted to $11,250 or more, depending on inflation adjustments. By aggressively contributing from her own salary, Linda is essentially laundering her taxable income into a tax-shielded vehicle, effectively replacing the capital she lost during the divorce at an accelerated rate. Social science data on late-life divorce suggests that individuals who utilize these catch-up provisions within the first 36 months of their divorce are 40% more likely to reach their original retirement lifestyle goals compared to those who simply let the remaining balance sit. However, we must also look at the administrative cost of this recovery. In 2026, plan administrators have shifted much of the QDRO processing cost onto the participants. It is a historical trend that used to see companies absorbing these legal costs as a benefit of employment. Now, it is common to see flat fees of $500 to $1,500 deducted directly from the 401k balance just to review the paperwork. If you have multiple accounts from various past employers, a common situation in the 2026 gig and pivot economy, you could be looking at $5,000 in purely administrative fees before a single cent is transferred. The complexity of the 2026 workforce means that a single person might have 4 different 401k accounts from 4 different decades of work. The social science of workforce volatility shows that the average American now changes jobs 12 times in their career. In a divorce, each one of those accounts requires its own subpoena, its own valuation, and its own QDRO. If you forget even one small account from a job you held in 2012, and that account has grown from $5,000 to $25,000 through passive index investing, you are leaving a significant asset on the table. This brings us to the concept of the 401k shadow asset. Some companies offer supplemental executive retirement plans or SERPs that look and act like 401ks, but are governed by different sections of the tax code. These are non-qualified plans. They are not protected by ERISA in the same way. If a company goes bankrupt, the money in a standard 401k is safe because it is held in a trust. The money in a SERP or a non-qualified plan is considered a general asset of the company. If the company fails in the 2026 economic environment, that retirement money could vanish to pay off corporate creditors. Understanding the difference between a qualified and a non-qualified plan is the difference between a secure retirement and a total loss. As we examine the psychological landscape of these transfers, we see that the stress of the 401k split often leads to what researchers call financial paralysis. People become so afraid of making a mistake with the QDRO that they do nothing. They leave the funds in their ex-spouse plan for years after the divorce is final. This is a high-risk gamble. If the ex-spouse takes a loan, defaults on a debt, or passes away without the QDRO being finalized, the alternate payee's claim becomes exponentially harder to enforce. In 2026, the speed of digital transactions means that an account can be emptied in minutes, but the legal system still moves at the speed of paper. Why is it that even in a high-stakes divorce, people ignore the most valuable asset in their portfolio? It is because of the complexity of the math. But as we move forward, the math is about to get even more complicated. There is a hidden interaction between your 401k and another massive US system that most people forget until it is too late. It is a system that can penalize you for having too much in your 401k or take away your benefits because of how your 401k was divided. In our next part, we are going to dive into the intersection of the 401k and Social Security. We will explore the windfall elimination provision and how your divorce settlement could accidentally trigger a permanent reduction in your monthly Social Security checks. We will also look at the dark side of 401k beneficiaries, specifically what happens when your ex-spouse remarries before the QDRO is processed, creating a three-way legal war between the ex-wife, the new wife, and the federal government. The stakes are rising, and the rules of 2026 are unforgiving. The three-way war begins the moment the ink is dry on a second marriage license, while the first marriage's retirement assets are still in legal transit. In the social sciences of American family law, this is known as the survivor benefit collision. To see this in action, we must look at a case study from the high-stakes environment of 2026. Imagine a character named Robert. Robert is a senior medical consultant who recently finalized a divorce from his wife of 22 years, Janet. Their divorce decree, signed by a state judge in early 2026, clearly stipulates that Janet is entitled to 50% of Robert's $1.2 million 401k. However, the legal team has not yet finished drafting the Qualified Domestic Relations Order, or QDRO, to send to the plan administrator. 3 months after the divorce, Robert remarries a woman named Sarah. Under the federal guidelines of ERISA Section 205, a new spouse automatically acquires certain rights to a participant's retirement plan. Specifically, Sarah now holds a federal statutory right to a qualified pre-retirement survivor annuity, or QPSA. This means that if Robert were to pass away before the QDRO for Janet is officially qualified and processed by the plan administrator, the plan is federally mandated to pay the survivor benefits to the current spouse, Sarah, regardless of what Janet's state divorce decree says. In mid-2026, Robert unexpectedly suffers a health crisis and passes away. Now, the plan administrator is caught in a legal crossfire. Janet presents the divorce decree and the draft QDRO, claiming her 50% share of the $1.2 million. Sarah presents her marriage certificate and invokes her federal rights as the surviving spouse. Social science research into federal preemption shows that in the absence of a finalized, qualified QDRO, the plan administrator's primary duty is to the person defined as the spouse under federal law at the time of death. Janet is left holding a piece of paper from a state court that the federal plan administrator may legally ignore. This historical trend of the race to the plan administrator has led to some of the most bitter and expensive litigation in U.S. history, as ex-spouses find themselves suing new spouses in federal district court to recover assets that were supposedly theirs by right. The potential outcomes in this scenario often hinge on whether the plan's record keeper had received a formal notice of a domestic relations order before the death occurred. In 2026, advanced legal strategies involve filing a joinder or a preliminary injunction with the plan administrator immediately upon the filing of a divorce petition. This acts as a digital tripwire, preventing the participant from changing beneficiaries or allowing a new spouse's rights to supersede the ex-spouse's interest until the QDRO is finalized. This conflict leads us directly into the complex intersection of the 401k and the U.S. Social Security system. Social scientists have identified a critical knowledge gap regarding the 10-year rule. In the United States, if a marriage lasted 10 years or longer, a divorced person can claim Social Security benefits based on their ex-spouse's earnings record, provided they are at least 62 and unmarried. However, many people in 2026 mistakenly believe that dividing a 401k reduces the amount of Social Security they can receive from their ex-spouse's record. This is a common misconception. The division of a 401k is a private property settlement. It does not diminish the Social Security credits earned by either party. However, there is a dangerous exception known as the Windfall Elimination Provision, or WEP, and the Government Pension Offset, or GPO. Imagine if Robert had been a government employee for a portion of his career, contributing to a 403b or a specialized 401k style plan instead of Social Security. If Janet receives half of that 401k in 2026, the Social Security Administration may view that distribution as a periodic payment from a non-covered pension. This can trigger the GPO, which could potentially reduce Janet's spousal or survivor Social Security benefits by 2/3 of the amount of her 401k distribution. For many women in the gray divorce demographic of 2026, this results in a net loss of income. They win the battle for the 401k but lose the war for their monthly Social Security check. The 2026 economic environment has made this math even more volatile due to the higher cost of living adjustments, or COLA, applied to Social Security. If a person receives a large lump sum for 401k split via QDRO, they must carefully calculate whether that lump sum will provide more long-term value than the Social Security benefits they might be forfeiting through the GPO. Social science data suggests that individuals who do not account for the WEP and GPO during their divorce negotiations often experience a 20% standard of living drop in their mid-70s when they transition from work to full retirement. To navigate this, step-by-step due diligence is required. First, you must determine if any portion of the 401k was earned in a job where Social Security taxes were not paid. Second, you must model the present value of the Social Security benefit versus the tax-adjusted value of the 401k share. Third, in 2026, many experts recommend using a Social Security offset in the divorce settlement. This is where one spouse agrees to take a smaller portion of the 401k in exchange for the other spouse not contesting a higher alimony payment that compensates for the lost Social Security income. Furthermore, we must address the sociological impact of the 10-year rule on remarriage. If Janet, in our case study, were to remarry before the age of 60, she would lose her right to claim Social Security on Robert's record entirely. In the social sciences, this is known as the remarriage penalty. It creates a perverse financial incentive for older divorcees to cohabitate rather than legally remarry. In 2026, we are seeing a historical trend of silver cohabitation, where individuals stay legally single specifically to protect their access to an ex-spouse's Social Security benefits, while also retaining their share of the 401k. The interaction between these two systems, the private 401k and the public Social Security safety net, is the most common point of failure in modern U.S. retirement planning. It requires a level of actuarial precision that the average divorce attorney is simply not trained to provide. This is why the role of the certified divorce financial analyst has become so prominent in 2026. They are the ones who can bridge the gap between the mahogany courtroom and the cold mathematics of the Social Security Administration's manual. As we look deeper into the 401k split, we find that even when the Social Security issues are resolved, there is a final hidden hurdle in the 401k world: the basis calculation error. This is a technical glitch that can lead to the IRS coming after your 401k share years after the divorce is finalized. Most people assume that once the money is in their own account, they are safe. But the IRS has a long memory, and if the basis, the amount of already taxed money in the account, wasn't divided correctly, you could be in for a shock. In our next part, we are going to explore the tax basis clawback and the nightmare of the non-spouse beneficiary. We will look at what happens when a 401k is divided but contains after-tax contributions that neither spouse's lawyer accounted for. We will also dive into the world of 401k hardship withdrawals and how a spouse can legally drain an account before the divorce is even filed, leaving the other party with 50% of zero. The digital traces of your retirement are being tracked in real time in 2026. And if you aren't watching the data, you aren't seeing the whole picture. The digital traces of your retirement are being tracked in real time in 2026. And if you are not watching the data, you are not seeing the whole picture. This brings us to a technical nightmare that social scientists have termed the basis blunder. To understand this, we have to look at the anatomy of a 401k contribution. Most people contribute pre-tax dollars, which grow tax-deferred and are taxed as ordinary income upon withdrawal. However, a significant number of high-earning Americans in 2026 also make after-tax contributions to their 401k plans. These are not Roth contributions. They are a separate category where the principal has already been taxed, but the earnings are still tax-deferred. Imagine a character named Michael. Michael is a software architect who has been maxing out his 401k for 12 years. Over that time, he has put in $100,000 of after-tax money. In 2026, as he and his spouse, Emily, prepare to divide his $600,000 account, the attorneys focus solely on the $600,000 bottom line. They agreed to a 50-50 split. Emily receives $300,000 through a qualified domestic relations order and rolls it into a traditional IRA. Michael keeps the remaining $300,000. On the surface, it is a clean break. However, Michael's $300,000 portion contains the entire $100,000 tax basis. When Michael retires, $100,000 of his withdrawals will be completely tax-free. Emily's $300,000, however, is entirely pre-tax because the tax basis was not specifically allocated in the QDRO. Social science research into financial equity indicates that this failure to account for tax basis results in a hidden wealth transfer of tens of thousands of dollars. In 2026, the IRS uses automated matching systems to track the cost basis of retirement accounts. If the QDRO does not explicitly state that the tax basis should be shared pro rata, the plan administrator usually defaults to keeping the basis with the original participant. This means Emily is essentially paying Michael's future taxes. A potential outcome of this scenario is that 5 years later, when Emily realizes the discrepancy, her legal recourse is almost non-existent because the QDRO is already finalized and the plan is closed. This leads us to the most aggressive tactic seen in 2026 divorce litigation: the predatory hardship withdrawal. Under the expanded rules of the Secure 2.0 Act, which are in full effect by 2026, participants have much easier access to their funds through self-certified hardship withdrawals. If a participant claims an immediate and heavy financial need, such as preventing foreclosure, paying for a sudden medical emergency, or even certain educational expenses, they can pull money out of the 401k. Imagine a scenario where a participant named Chris realizes his spouse is about to file for divorce. Chris knows that once the paperwork is filed, an automatic temporary restraining order usually goes into effect, freezing all marital assets. To preempt this, Chris applies for a $50,000 hardship withdrawal, claiming it is for an urgent home repair. Because the 2026 systems allow for self-certification, the plan administrator processes the request in 48 hours. Chris takes the cash and moves it into an offshore account, or spends it on untraceable luxury goods. By the time the divorce begins, the 401k is $50,000 lighter. In the social sciences, this is categorized as the dissipation of marital assets. While a judge can order a credit or an offset from other assets to compensate the spouse, the reality in many 2026 cases is that there are no other assets of equal value. If the 401k was the only major holding, the other spouse is left fighting for 50% of a diminished or empty shell. This is why forensic accountants in 2026 are increasingly looking at the digital breadcrumbs of retirement plan portals. They are checking the logs for when the participant last changed their password, when they downloaded a loan application, and if they recently updated their mailing address to a P.O. box to hide incoming distribution checks. We must also confront the nightmare of the non-spouse beneficiary. In 2026, the intersection of federal ERISA law and state probate law creates a vacuum where many children of a first marriage lose their inheritance. Consider a case study where a participant named Sarah has a 401k and names her adult son, Kevin, as the beneficiary. Sarah then marries her second husband, David. Under ERISA, the moment Sarah marries David, David becomes the legal beneficiary of the 401k unless he signs a written waiver. Sarah, wanting to ensure Kevin is taken care of, never asks David to sign the waiver, assuming her original designation still holds. When Sarah and David eventually divorce in 2026, the divorce decree states that David waives all interest in Sarah's retirement accounts. However, Sarah never goes back into the system to redesignate Kevin. If Sarah passes away shortly after the divorce, a legal war erupts. Kevin points to the divorce decree. David points to the fact that he was never officially removed and that as a former spouse, he may still have a claim if the plan documents were not updated. Historical trends show that the U.S. Supreme Court has consistently favored the plan documents over the divorce decree. This means that despite a clear intent to leave the money to her son, the ex-husband David may walk away with the entire account. Social scientists point to this as a failure of the administrative state to align with the complexities of modern blended families. As we move further into the mechanics of 2026, we see the rise of the 401k shadow account audit. Many major U.S. employers now offer multiple tiers of retirement savings: the 401k, the 401k Roth, and the non-qualified deferred compensation plan. In a divorce, a spouse might only subpoena the 401k statements, completely unaware that the participant has a shadow account where the company contributes a percentage of their salary that exceeds IRS limits. These accounts are often invisible to standard financial discovery because they do not appear on the same statement as the 401k. In 2026, the social science of wealth concealment has evolved. Participants are increasingly using these non-qualified plans as a vault to hide income from their spouses. Since these plans are not protected by ERISA, they do not require a QDRO for division, which ironically makes them easier to hide because there is no federal oversight. Finding these assets requires a step-by-step review of the participant's employment contract and their year-end W-2 forms. If the W-2 shows a discrepancy between the total compensation and the amount subject to Social Security tax, it is a red flag that money is being funneled into a shadow account. Why is this transparency so hard to achieve? It is because in 2026, retirement plans are decentralized across dozens of fintech platforms. A single employee might have 4 different login portals for their various benefits. The cognitive load of tracking these accounts leads to what researchers call financial opacity by exhaustion. Spouses give up on finding every last dollar because the search is too technically demanding and legally expensive. But there is a reckoning coming. While you can hide an asset during the divorce, you cannot hide it from the IRS forever. In 2026, the 1099, our reporting system is more integrated than ever. Every time a 401k is divided or a loan is taken, a data point is generated that will eventually trigger an audit if the math does not add up across both spouses' tax returns. In our next part, we are going to dive into the IRS audit storm. We will explore how a poorly drafted QDRO from 2026 can trigger an audit in 2029, dragging both ex-spouses back into a legal battle long after they thought they were free. We will also look at the rise of the AI-driven QDRO examiner and how companies are using algorithms to automatically reject any court order that does not perfectly match their internal code. If your lawyer is not writing for the algorithm, you are not going to get paid. Writing for the algorithm is the new gold standard in 2026. If your legal counsel is still drafting qualified domestic relations orders based on templates from 2015, you are essentially submitting a dead letter to a machine that doesn't care about your intent. In the current landscape, major plan administrators like Fidelity, Vanguard, and Empower have moved to fully automated compliance engines. These AI-driven examiners are programmed to look for specific syntax and mandatory federal markers. If a single phrase is missing, such as the exact legal name of the successor plan or a precise definition of the valuation date, the system triggers an automatic rejection within milliseconds. This creates a psychological and financial loop of frustration where couples pay thousands for a lawyer to fix a document that a machine keeps spitting back. This brings us to the most delayed but devastating phase of the 401k divorce, the IRS audit storm. To understand the potential outcomes, we need to look at how the IRS has integrated its data systems with the Social Security Administration and major financial record keepers by the year 2026. The IRS now uses a high-velocity reconciliation process. When a 401k distribution occurs, the plan administrator issues a Form 1099-R. If that 1099-R is coded as a distribution to an alternate payee under a QDRO, it is supposed to be tax neutral for the participant and taxable only to the ex-spouse. However, if the QDRO was poorly drafted or the plan administrator made a clerical error during the AI processing phase, the 1099-R might be issued in the participant's name instead. Imagine a case study involving Mark and Jennifer Miller in 2026. Mark has a $1.2 million 401k. Jennifer is awarded $600,000. They finalize their divorce in June, and the money is transferred in August. Mark believes his liability is over. Jennifer rolls her $600,000 into an IRA but takes a $50,000 distribution to pay for her new housing costs, correctly assuming she won't pay the 10% early withdrawal penalty because of the QDRO exception. Fast forward to 2028. The IRS automated matching system flags a discrepancy. Because the QDRO lacked a specific tax identification clause that the 2026 AI systems require, the plan administrator reported the entire $600,000 transfer as a taxable distribution to Mark, not Jennifer. Suddenly, Mark receives a notice of deficiency for over $200,000 in unpaid taxes, interest, and penalties. Jennifer also receives a notice because her $50,000 withdrawal didn't have the correct exception code on her tax return to match the flawed 1099-R. This is the audit storm. It hits 2 to 3 years after the divorce is a distant memory, dragging both parties back into a shared nightmare. The historical trends of the mid-2020s show that these administrative mismatches have increased by 40% as human oversight in benefits departments has been replaced by algorithmic processing. To audit-proof your 401k division in 2026, you must follow a rigid step-by-step verification process. Step 1 is the pre-approval request. You should never sign a final divorce decree until the plan administrator has provided a written pre-approval of the draft QDRO. In 2026, this is often done through a digital portal where you upload the PDF and receive a green light from the AI examiner. Step 2 is the 1099-R reconciliation clause. Your settlement agreement must explicitly state that the participant and the alternate payee will cooperate to correct any misreported tax forms, and that the party responsible for the error will indemnify the other for any resulting tax or legal costs. This leads us to a critical sociological concept known as the alimony recapture trap, specifically under Internal Revenue Code Section 71. While the 2017 Tax Cuts and Jobs Act changed the taxability of alimony for federal purposes, the social science of 2026 negotiations shows that many couples are still using 401k payouts to mimic the function of alimony. Imagine if Jennifer agrees to waive her right to monthly alimony in exchange for a larger share of Mark's 401k. If the IRS perceives this as an attempt to circumvent tax laws, or if the payments are structured in a way that looks like front-loading, it can trigger a recapture rule. This results in the IRS reclassifying the property settlement as income, leading to a massive unexpected tax bill for the person who thought they were receiving a tax-free asset. The year 2026 also sees a rise in the use of Form 5329. This is the form where you claim your exception to the 10% early withdrawal penalty. Social science research suggests that over 60% of divorced individuals fail to fill out this form correctly, leading to auto-generated bills from the IRS. You must use exception code 06, which specifically identifies a distribution made under a qualified domestic relations order. If you simply assume the IRS knows it was a divorce settlement because your lawyer told you so, you are inviting an audit. The IRS in 2026 operates on data matching, not on the nuances of your personal life. Furthermore, we must address the sociological divide that technology is creating in the U.S. legal system. For high-net-worth individuals, the cost of higher specialized QDRO actuaries and tax attorneys is a rounding error. However, for the average American with a $150,000 401k, the complexity of 2026 compliance acts as a regressive tax. They are more likely to use self-help legal portals or generalist attorneys who don't understand the algorithmic requirements of modern plan administrators. This results in a historical trend where the middle class is disproportionately affected by rejected orders and tax audits, further widening the retirement wealth gap between those who can afford technical precision and those who cannot. Consider the psychological warfare of the 401k freeze. In 2026, many fintech-driven 401k plans have implemented a lock-on notice policy. The moment a participant or a spouse calls the customer service line and mentions the word divorce, the account is electronically flagged. This trigger can happen months before a lawyer is even hired. This freeze prevents the participant from taking loans, but it also prevents them from reallocating their investments. If the market becomes volatile during the months of negotiation, the participant is trapped in their current positions, unable to hedge or move to cash. Social scientists have noted that this lack of control often leads to high-stress decision-making, where one spouse may give up significant long-term assets just to get the freeze lifted, so they can manage their portfolio again. We are also seeing the emergence of the 401k beneficiary clawback. In 2026, if a QDRO is not finalized and a participant dies, leaving the money to a new spouse, some states have attempted to pass revocation on divorce statutes to protect the first spouse. However, because of ERISA preemption, these state laws are often powerless. The sociological impact is a growing distrust in the retirement system's ability to honor the true intent of the workers. People feel that their 401k is no longer theirs. It is a ward of the federal government and the corporate algorithm. As we reach the final stages of this deep dive masterclass, we have covered the laws, the taxes, the AI gatekeepers, and the psychological traps. But there is one final, ultimate question. What is the golden rule of 2026 retirement division that ensures you don't just win the settlement, but actually keep the money? There is a single overlooked document that acts as the master key to the entire 401k system. If you don't have it, your QDRO is just a piece of expensive paper. In our final part, we are going to reveal the master key document and provide the ultimate checklist for future-proofing your retirement in a post-divorce world. We will look at the 2027 outlook for retirement law and how the next wave of legislation could retroactively change the way your 401k is taxed. We will also explore the final case study of a couple who did everything right, only to find a loophole that no one saw coming. The finish line is in sight, but the final hurdle is the highest one of all. The final hurdle that stands between a signed court order and the actual possession of your retirement future is the letter of determination. In the social science of federal benefits, this document is the master key. You can have a divorce decree signed by the most powerful judge in your state, but until the 401k plan administrator issues a formal, written notice stating that your domestic relations order has been qualified, you have nothing but an expensive piece of paper. This qualification process is the moment where the abstract law of the courtroom meets the cold, binary reality of ERISA record-keeping. Imagine the final case study of this masterclass, the story of Gregory and Susan in late 2026. After a 3-year legal battle over Gregory's high-value 401k, they finally reached a settlement. Their attorneys drafted a qualified domestic relations order that was a masterpiece of legal precision. It accounted for every market swing, every loan offset, and every tax basis nuance we have discussed. The judge signed it. Susan's attorney mailed it to the plan administrator. Susan felt a sense of relief, believing the finish line had been crossed. She began making plans to use her portion of the funds to purchase a modest townhome, ending her season of housing instability. However, they encountered a loophole that no one saw coming: the plan termination trap. While the QDRO was sitting in the plan administrator's queue for the standard 30-day review period, Gregory's employer, a legacy manufacturing firm, filed for Chapter 11 bankruptcy. As part of the restructuring, the 401k plan was terminated. In the social sciences of corporate collapse, a plan termination is a high-velocity event. When a plan terminates, the assets must be distributed to participants or rolled over into a successor plan immediately. Because Susan's QDRO had not yet been officially qualified, she was not yet recognized as an alternate payee in the system. The record keeper, following the automated termination protocol, issued a full distribution check to Gregory for the entire balance. This created a catastrophic legal vacuum. Under federal law, once the plan is terminated and the funds are distributed, the plan administrator's fiduciary duty ends. Susan could no longer look to the 401k plan for her money. Her only recourse was to sue Gregory personally in state court for contempt and a return of the funds. But Gregory, seeing the check as a windfall in the chaos of his company's collapse, had already moved the money into a complex series of offshore vehicles. Susan's case study serves as a stark warning for 2026. The time between the signing of the decree and the issuance of the letter of determination is a zone of extreme risk. Historical trends show that in periods of economic transition, like the corporate shifts predicted for 2027, the speed of your QDRO processing can be the difference between retirement security and total loss. To future-proof your retirement in this volatile environment, you must implement the 2026 post-transfer audit. This is a step-by-step checklist designed to ensure that the wealth redistribution actually sticks. Step 1 is the verification of the valuation. When the funds finally arrive in the alternate payee's account, you must compare the starting balance against the market data for the exact valuation date specified in the order. In 2026, many record keepers use automated daily compounding. If the plan administrator missed even 2 days of market growth on a 7-figure account, the discrepancy can be thousands of dollars. Potential outcomes of a successful audit include the recovery of these missing gains through a supplemental QDRO. Step 2 is the immediate redesignation of beneficiaries. We have discussed the danger of leaving an ex-spouse on a beneficiary form, but the post-transfer phase has its own trap. When Susan finally received her funds into a new rollover IRA, that account was a brand new legal entity. If she failed to name a beneficiary on that new account, and she passed away shortly after, the assets would default to her estate, triggering a lengthy and expensive probate process. In the social sciences of wealth transfer, the failure to name a beneficiary on a newly formed rollover account is a leading cause of unintended inheritance patterns in the U.S. Step 3 involves the coordination of the 1099-R. In January of 2027, both Gregory and Susan will receive tax forms from the 401k plan. They must ensure that the codes in Box 7 match the intent of the QDRO. For Susan, the distribution should be coded to show it is a transfer to an alternate payee, exempting her from the 10% penalty if she took a cash distribution under the 72T exception. If the record keeper uses the wrong code, Susan will face an automated audit from the IRS. Historical trends suggest that the IRS is increasing its use of AI-driven mismatch detection in 2026 and 2027, making this clerical check mandatory for anyone hoping to avoid a 3-year audit cycle. Looking forward into 2027, We must anticipate the next wave of retirement legislation, often discussed in policy circles as Secure 3.0. Social science researchers are tracking potential outcomes that could include the mandatory Rothification of all catch-up contributions and new rules regarding the valuation of digital assets within 401ks. For those currently navigating a divorce, this means your settlement language must be flexible enough to account for changes in the tax code that could happen after the papers are signed, but before the money is spent. You are not just negotiating for today's dollars. You are negotiating for 2027's purchasing power and 2030's tax brackets. The social science of the 401k divorce ultimately reveals a fundamental shift in the American family structure. The retirement account has become the modern-day hearth, the center of the home's economic value. Dividing it is a surgical procedure on the family's future. It requires more than just legal knowledge. It requires a deep understanding of the intersection between federal mandates, corporate record-keeping, and human psychology. Those who approach this process as a mere math problem often fail. Those who approach it as a comprehensive masterclass in asset protection are the ones who emerge with their retirement dreams intact. As we conclude this deep dive, remember that the U.S. retirement system is a labyrinth designed for workers, not for divorcees. The rules were written to keep money in the plans, not to move it between ex-spouses. To navigate the exits, you must be more than a participant. You must be a strategist. You must watch the data, verify the algorithms, and never assume that the system is working in your favor. The wealth you save today is the freedom you enjoy tomorrow, but only if you secure the master key. The complexity of the 401k is just the beginning of the broader redistribution of American wealth. As the 2026 landscape continues to evolve, we are seeing the emergence of new asset classes that are even more difficult to divide than a traditional retirement account. From tokenized real estate to private equity vehicles tucked inside self-directed IRAs, the next frontier of divorce litigation is already here. In our next series, we will break down the invisible wealth of 2027, exploring the world of executive shadow compensation and the digital vaults that most divorce attorneys don't even know exist. If you think a 401k is a complex asset, you haven't seen what happens when the marital estate includes decentralized finance and private placement memorandums. The masterclass continues as we move from the public record into the private ledgers of the high net worth American divorce.